Hearing of the City of Cape Canaveral. My name is Rick Geller. I'm Special Magistrate appointed by the City Council to hear code enforcement cases pursuant to Chapter 162 of the Florida Statutes and Article 6 of the Cape Canaveral City Code. This will be a quasi-judicial evidentiary proceeding. The burden of proof shall be on the city to show by a preponderance of the evidence that a code violation exists. In other words, I will determine based on the evidence presented to me this evening whether it is more likely than not that a violation has occurred or continues to occur. I have looked at the materials in the agenda packet, and I will surmise from them that the affirmative defense of equitable estoppel will be asserted. I will say that the case law on that is such that the burden of proof shifts to the person asserting an estoppel, in this case, the enforcement of a code provision should be stopped. In any event, the alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by the city or by the responding party. Anyone who would like to testify, we do have a sign-in sheet at the front of the chambers here. Would ask anyone from the public to sign that if you're not either the city or the responding party, and to indicate for whom you would like to give testimony. Upon request, I will allow any alleged violator to ask relevant and material questions of any city witness, and then vice versa. The city may ask relevant and material questions of any witnesses for the responding party, again, upon request. Any other requests, I'm happy to oblige. For example, any kind of closing argument, opening statement, and the like. I may exclude evidence that I deem irrelevant, immaterial, or repetitious. I don't believe that we have any proceeding to issue fines this evening, which is known as a Massey hearing. But if there has to be a subsequent proceeding where a fine is considered, it's my obligation under the law to consider the gravity of the violation, any actions taken by the violator to correct the violation, and as well as any previous violations under the history of this particular responding party or any responding party. Under the city code and the Florida statutes, I may assess and order payment of a fine of up to $250 per day for a first violation, or in the case of repeat violations, if that is demonstrated, up to $500 per day, as well as $5,000 for violations that I would deem irreparable or irreversible. I would tell you that is extremely rare. I'm also able to assess costs of any repairs that the city may make in these cases. At the conclusion of the hearing, I do endeavor to issue findings of fact and conclusions of law based on the evidence of record, and I will render an order, typically here on the bench and in writing. In some circumstances, if a case is complicated, I may need to take the matter under advisement. So I'm just letting everyone know up front. If a order is issued imposing a fine, the city can record that in the public records of Brevard County, and that would then become a lien against the property where the violation occurs, as well as any other personal or real property owned by someone who is deemed to be a violator of the code. Any order that I issue may be appealed by any aggrieved party, either a responding party or the city, to the Circuit Court for Brevard County within 30 days. It is the responsibility of the party appealing the order to obtain a record of these proceedings. Appeals are limited to the record that is presented to me, and the city's agenda packet will be administratively accepted into evidence as City's Exhibit 1, and the PowerPoint slides as Exhibit 2. The next hearing, just for some administrative matters, will be on January 27, 2026, so we won't be seeing anyone for a few months, it seems like. I did approve of the minutes for the hearing that I last held on July 22nd, 25, and I gave the signed minutes to the recording secretary, Ms. Roth. And at this point, I would like to ask anyone who will be offering sworn testimony to please rise and raise your right hand to be sworn in. Do you swear or affirm that the testimony you will give this evening shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. First item on the agenda is case number 25-173. It alleges a violation of Section 94-1, the sign code of the City of Cape Canaveral, as well as Section 94-31, in which permits are required. And I'll let you proceed, Officer Coates, if you're ready.
Yes, sir. Mr. Geller, before we get started, I'd like to point out that I've got Senior Planner Connor Ford here, and as well as the city attorneys.
I'm sorry, I missed the name there?
Connor Ford.
Connor Ford?
Yes, you got it.
Okay.
Case number 25-173, McKibben Home Group, Cape Canaveral, Garden Inn Limited Partnership, a foreign limited partnership presented by Code Enforcement Manager Gerald Coates. Address is 150 Imperial Boulevard. The legal and parcel is written. Zoning is C2 Commercial Manufacturing District. Owner is McKibben Hospitality Group, Cape Canaveral, GILP, a foreign limited partnership. The business is Hilton Garden Inn Hotel. Summary of code violations. There are 2 code violations for the same wall sign installed on southern oriented building elevation. Violation number 1, wall sign installed without a permit, Section 94-31, sign permits required. Violation number 2, the wall sign exceeds maximum allowable size of 160 square feet. Section 94-96-1, the table district restrictions for C2 zoning. Notice of violation was sent September 12, 2025, sent certified mail. Received receipt on September 16th, 2025. Notice of hearing was sent September 30th, 2025, certified mail. This is the original October 28, 2025 hearing date. On October 2nd, 2025, assigned return receipt via USPS tracking. On October 23rd, 2025, a notice of cancellation as requested by respondent's attorney, Jim Coyle. On October 24th, 2025, a notice of hearing was reissued for November 5th, 2025 hearing date, which is today. On October 24th, 2025, an email from a respondent's attorney acknowledging the November 5th hearing. This is a view of the property as listed for today. Relevant timeline of events. This is December 16th, 2024. A signed permit application filed by respondent's contractor, Dynamic Aspects Incorporated, requesting approval of multiple signs. Permit 24-1733 for a 127.8 square foot wall sign on the western elevation. Permit number 24-1737 for a 250.5 square foot wall sign for southern elevation. Permit 24-1739 for a ground sign.
And if I can interrupt you here,
Sure.
It's the red permit that we're concerned about this evening?
Yes, sir.
The other 2 permits are irrelevant, correct?
Yes, sir.
Okay, thank you.
They're just what was filed on the 12/16/2024 date.
Right.
Okay, 12 December 19th through the 20th, 2024, text messages exchanged between Brian Morgan, Vice President of Construction, and Craig Green, the city deputy building official, referencing a permit application was filed. On December 20th, 2024, the deputy building official issues permit decisions. Permit 24-1733 for a 127.8 square foot wall sign for western elevation approved. Permit 24-1737 for a 250.5 square foot wall sign for southern elevation denied. That's the sign in question right now. Permit 24-1739 ground sign approved. On December 20th, 2024 at 3:03 p.m., the deputy building official's notice of permit denial, permit 24-1737, issued by city's electronic permit system to sign contractor at Kelly G at dynamicaspects.net. February 20th of 2025, permit 24-1737, sign application reassigned to Connor Ford, the city planner. February through April, communications between Connor Ford and signed contractor Dynamic Aspects for a wall sign for southern elevation exceeds the maximum size allowed by city code. A variance approval will be required to obtain sign permit. On April 22nd, 2025, Connor Ford emails variance application to Kelly G at dynamicaspects.com and Tim Fiske at onestratus.com. On May 27th, 2025, variance application filed by attorney Jim Coyle.
Just, if I can interrupt you, do we know who is One Stratus? Who is Tim Fiske?
Yeah, that's the signage.
I'll let you. I appreciate you offering the information, but if
Again, Connor Ford, senior planner. From what I understand, they're the ones that designed the plans. Is that accurate, or?
Yeah, they're the sign manufacturer.
Okay, yeah, they're the sign manufacturer. One Stratus, it's a company.
Okay, One Stratus is the sign manufacturer. Thank you.
On May 27th, 2025, variance application filed by attorney Jim Coyle on behalf of McKibbing Hospitality Group, Cape Canaveral, GILP, Hilton Garden Inn, seeking variance to permit a 250.5 square feet wall sign on the southern elevation, 160 square foot maximum wall sign allowed by code. On May 27th, 2025, variance application discussed between Brian Morgan, Vice President of Construction, and Nicholas Posey, Associate Project Director, and Connor Ford. MSG advised signed drawings must be submitted for variance application. On June 30th, 2025, variance application amended and supplemented with additional information and signed drawings prepared by Stratus, onestratus.com. On July 17th, 2025, Board of Adjustments considers and approves 2-1 variance application. City staff report recommended denial of variance based on noncompliance with variance criteria. On July 25th, 2025, MHG provided 2 letters from city staff. Board of Adjustments decision letter and notice of appeal of a Board of Adjustment decision to City Council filed by City Community Development Director. On August 19th, 2025, City Council considers appeal, reverses the Board of Adjustment decision, and denies the variance application. MSG representatives present at the City Council meeting. On August 21st, 2025, a variance denial letter sent to MHG. MHG does not appeal the council's decision. On August 26, 2025, City Planning conducts final site inspection, for hotels subject to conditions. Ensure all applicable permits and inspections will be secured in regard to signage. August 26, 2025, the building official conducts final building inspection and issues certificate of occupancy for hotel building. September 7th, 2025, Connor Ford observes wall sign installed on upper level south facade of the building, oriented perpendicular to Imperial Boulevard. Same sign previously denied, sign permit 24-1737 and variance. September 11th, 2025, a notice of violation sent to the property owners.
Can you just back up? I'm getting some of these dates. So the certificate of completion, certificate of occupancy, that was issued the same day as the final site inspection on 8/26/25. Do I have that correct?
8/26/2025, yes, sir.
That's the, okay.
The notice of violation was sent to the property owners on September 11th, 2025. September 16th, 2025, notice of violation received by the property owners. On September 19th, 2025, a letter received from Attorney Coyle admitting sign installed in violation of code. We understand that the sign as installed is in violation of the ordinance, paragraph 1, page 1's paragraph, second paragraph. On October 24th, 2025, a revised notice of hearing issued. Here's what the dimensions are for the sign. It's a large area. Here's a smaller area. Dimensions are 250 square foot. Here's a picture of what the sign looks like. This is a better view, a longer from far away. This is another view. You're facing the front of the building from Imperial Boulevard. Another view. Property representative.
All right. So just before you sit down, so and the day that we observed, that the city, when I say we, the city observed the installation, that was on September 7,
Yes, sir.
2025. Okay, I got it.
Okay.
All right, representative for the developer.
Can I move that?
Yep, and
Sorry.
Move this out of your way.
Yeah, thank you, Mr. Coates.
feel free to take your time to get yourself set up. We're in no hurry, no rush.
Correct. So, I am Jim Coyle, the in-house general counsel for McKibben Hotel Group and its affiliates, one of which is MHG Cape Canaveral GI LP, the property owner. I have with me Brian Morgan, who's been referenced several times. He's Vice President of Construction for another related entity of the property owner, and that's McKibben Places. Brian was involved in the day-to-day construction of this project.
And I'm sorry, and the title again was about construction, Mr.
Vice President of Construction, is that correct, Brian? For
Vice President of
McKibben
Construction.
Places.
Okay, and Mr. Cole, you're the general counsel.
I'm the in-house general counsel.
Okay, and you spell your last name Coyle?
Coyle.
Got it.
Yes.
Okay.
So this is my first time before a special magistrate in Cape Canaveral on a sign variance non-compliance issue. So if I'm off with my procedure or my formality, I hope you'll bear with me and correct me and allow me some grace to keep going.
Well, we offer a lot of grace here. The formal rules of evidence do not apply in these proceedings, and I'm going to give both sides as much grace as both would like to give me the information that they believe I need to have to make a decision.
Thank you. I have 2 points that I want to talk about the one is about the process, and one is about the current status of the wall sign and the violation. And I don't have a PowerPoint or anything of that nature. I have some documents, most of which, I think all of which you already have, but if you if you need them, I have copies of them.
Okay, so these are you're referring to documents that are in the agenda packet? Okay.
Some may not, and I'll offer those up, and you may
Okay.
say yes, or you may say I don't.
Well,
really-
I'll accept any documents that,
Okay.
that you would like me to review.
Sure. Some of them really just validate what I'm saying, and that may not be. For example, we signed a contract with Stratus. You may not need that.
I won't need that.
Exactly.
I will assume that you've entered into a
Again,
contractual relationship
Not
with
knowing
the.
what we were doing, I wanted to make sure.
Although you may want me to have that if that shows the date of the contract, that shows when consideration was paid.
Sure.
But I'll leave that to you.
Sure. So my first point I want to make is about I think we had an invalid appeal of the Board of Adjustments decision. Pursuant to Cape Canaveral Code of Ordinances 110-33A1, it states in pertinent part, any party aggrieved by any final decision of the Board of Adjustment shall have the right to appeal that final decision to the City Council. Mr. Coates went through the timeline, and so you'll remember that on July 17th, the Board of Adjustments met and for our variance application and voted to approve that. They voted 2-1 to approve that. And they confirmed that in a letter to us on July 25th. That same day, Tamsin, and I think I'm pronouncing the name correct, Tamsin Bell, Director of the Community and Economic Development Department, filed the appeal. Again, Mr. Coates pointed that out, of the variance decision. And per the notice of appeal specifically, the appeal was actually filed by, quote, city staff as representatives of the Community and Economic Development Department. I have copies of that if anyone needs that. I think it's in the packet. If you need that, I can provide that to you.
So city staff as representatives of the Community and Economic Development
Yes, sir.
Department, or, okay.
Yes, let me just give that to
Okay.
you.
And if I have the notice of appeal already in the agenda packet, I can pull that up.
I can't remember. That was a
Just bear with
big
me a
general
moment, and
packet.
I'll confirm that I think I do recall seeing a notice of appeal. All right. Okay. So I have the notice of appeal, and that's going to be Respondents Exhibit 1.
Yes, thank you. So again, that appeal was actually filed by, quote, city staff as representatives of the Community and Economic Development Department, which is another government department here in the city of Cape Canaveral. In reviewing the agenda packet for tonight that Ms. Roth sent out, there were 4 pages entitled Board of Adjustment, BOA, July 17th, 2025, regular meeting, item 4. And again, I have that here. It's definitely in the agenda, but I have it here if you wanted to see it.
I don't know if this short circuits the argument or not, but my jurisdiction is to determine whether there is or was or was not a violation of the city code. If there was a procedural infirmity with the appeal, then I would have expected that to have been raised before the city council, and then you would have had appellate rights from that decision, I would assume, to the circuit court of Brevard County. I haven't looked at what the procedure is exactly. Do I have jurisdiction to render some kind of decision regarding an alleged procedural infirmity as to an appeal that's never was before me? It's
Understood, and you may or may not. What I'd like to do is get this argument on record in case we do file an appeal to this to the circuit court.
Okay, I'll let you proceed. Get your whole record on get your whole argument on the record.
Right. And so again, in the agenda packet for tonight, we had this Board of Adjustment, BOA, July 17, 2025, regular meeting, item number 4. I'm going to call that the memo. This memo lists the 6 criteria that the Board of Adjustment must consider in order to approve a variance application, and more importantly, has an opinion by the staff of the Community and Economic Development Department on each of those 6 criteria and whether or not, in their opinion, the variance applicant has satisfied those criteria. And all that's fine, because that too is set out in the code, that you have staff review that as a part of the process and provide their recommendations to the Board of Adjustments. And again, Mr. Coates pointed that out. That ultimately the Community and Economic Development staff recommended that they being the Board of Adjustments, deny the variance request. And this recommendation to deny was approved and signed by Tamsin Bell. Again, the very person who authored and filed the notice of appeal that you have there.
Okay.
So it seems unlawful to me that one government department can provide analysis and recommendations to another government department on a variance application, but they can also be an aggrieved party. Because remember, the Cape Canaveral Code of Ordinances states any party aggrieved by any final decision shall have the right to appeal. So I'm not so sure how they can also be an aggrieved party when simply the Board of Adjustments made a decision contrary to their recommendation. Have they suffered any financial harm? They being the Community and Economic Development Department in this instance. Has there been a violation of their rights in this instance? Does the Community and Economic Development Department even have legal standing? Aggrieved parties have all of those things. They have financial loss or potential for financial loss. They have potential violation of rights. They have legal standing. So I think the answer to my questions in this case, as it relates to the Community and Economic Development Department, is no. They're not an aggrieved party.
Well, I'm going to push back on that.
Okay.
To you. I think staff is representative of the city. The city is the aggrieved party, and city staff is entitled to make a recommendation to the trier of fact, whether it be the Board of Zoning Adjustment or to the City Commission on an appeal, on a de novo appeal, de novo review of what the Board of Adjustment did. The city itself would be the aggrieved party if there is a non-conforming sign that exceeds the square footage of what is allowed in the city code. So I think there would be standing to bring the appeal, and that's just how it would be done. Any aggrieved party can appeal a decision. If I were to rule in your favor tonight, the city could appeal my decision to the Brevard County Circuit Court,
Right, which is a much more
both,
traditional model.
Both sides could do that. So I'm not seeing that. So again, I'm doubtful that I really even have the jurisdiction to render a decision on a collateral attack on a alleged procedural infirmity as to a zoning adjustment matter when I got to stay in my lane, and my lane is there or was there a violation of the code? And feel free to respond to that.
Push back very quickly on your statement
Please.
that the city staff represents the city. I would also think the Board of Adjustments represents the city. They're an appointed board charged with hearing variance applications and deciding on those with recommendations from city staff.
Mm-hmm.
And I'm sure there have been many instances where they have gone with the recommendations, and there have been many instances where they've gone against the recommendations. Okay. And so it seems in opposition to what you said about this hearing, where you clearly have the property owner and the city at odds over a wall sign. Mm-hmm. In that situation, you had one city department and another city department arguably working together, but when the outcome is different from what the one who provides information and analysis to, they all of a sudden become an aggrieved party
Well,
to
if I could
city's decision.
And I don't mean to split hairs
Sure.
with you too much, but you have two different entities. You have the city staff representing the Community and Economic Development Department.
Right.
That's in and of itself. And then the Board of Zoning Adjustment, that is an official board of the city that makes decisions pursuant to the city code. And so I think they really are two different peas in the pod, so to speak. They are all under the auspices of the city. I would grant you that, but I would conclude that city staff did have the authority to bring an appeal, even assuming I had jurisdiction to consider the issue. So
Sure.
Anything else you want to add on that,
No,
that
again,
argument?
that's part of, again, we think the appeal process was invalid because
Okay.
they're not an aggrieved party.
Okay. What's the second? You had a
The second
contention.
point I want to make is the current status of the non-compliance. And I'm going to go quickly back through some of this timeline, not in the detail that Mr. Coates did. But the purpose of the timeline that I want to present is that it's important to show how we made our decisions in reliance on communications from the city of Cape Canaveral. Now, this is not a
Okay.
equitable estoppel defense. I'm not going there. What I'm wanting to get to, again, is the current status of the non-compliant sign.
So you're not alleging equitable estoppel tonight?
No.
Okay. All right.
This started for us, well, way back when, but the sign part started for us on August 30th, 2024, when we signed our contract with Stratus, the name we've heard before, for the design, fabrication, and installation of the wall sign.
I'm sorry, the date of that again?
8/30/24, August 30th, 24.
Contract
I
with
have a copy of the
Stratus.
contract if you'd like it.
Again, it wouldn't hurt for you to put it into evidence. So
Okay.
if you want to, we'll accept the contract as Exhibit 2.
Yes.
And do you have a copy of this for the city attorney?
I do.
Okay.
I've provided.
Very good. And also, if you give him a copy of Exhibit 1, or he has it?
He does.
Okay.
Provided him 1 and 2.
Thank you very much.
And so, once we executed that contract, Stratus got to work and we got to work. Stratus in designing the wall sign, and Brian and his team in working with the city and doing all the things to keep moving forward with the sign. On December 20th, as Mr. Coates described, there was text messages exchanged between Mr. Morgan and Craig Green. Craig Green is who we worked most closely with on this, and he was at that time the deputy building official. And again, I know that those text messages are in the agenda tonight, but I think it's important to read it very quickly, and it's not more than 3 messages. And this all occurred on December 19th. Mr. Morgan initiated the text messaging with, "Hey Craig, here are the sign permit numbers for HGI." Included is the sign in question. Craig Green responds, "Yes, got them all." Mr. Morgan responds, "Okay, great. Thanks for confirming. Will you be able to approve them today?" Craig says, "Maybe. If not, Monday." "Okay, thank you." So, again, the purpose of this timeline for us is to show why we made the decisions we did and why we got to this point.
Well, at this point, and I recall the text exchange or email exchange, whatever it
And I
was,
can
from the
provide you
agenda
with
packet.
those directly if you need them. I have
And
them.
I think they're already in
They
the
are.
in the agenda packet, and
They are.
But Mr. Green is not here, but I did not see anything written to or from Mr. Green that advised that the sign that is asked to be permitted exceeded the size that's allowed under the city code. So are we aware do we have any evidence that Mr. Green was made aware that there was a nonconformity there?
I'm aware of no written evidence to that effect.
Okay.
Okay. So, having built hotels in lots of places, this being our first time in Cape Canaveral, but based on our experience, we took that text message exchange, rightly or wrongly, we took that text message exchange and we authorized Stratus to begin the pre-wiring of the building. That was done the week of January 13th, 2025. They pre-wired the building. Okay?
What was it again? January what?
January 13th, 2025.
Okay. And when we're saying pre-wiring, we're talking, they're doing the wiring inside the walls, I assume from the interior of that roof area?
I may have to defer to Mr. Morgan on that, if I may.
You may.
Yeah, so basically
I'll tell you what, Ms. Morgan, if you would just come over to the microphone and introduce yourself so that your name gets on the record.
All right, yes, I'm Brian Morgan, Vice President of Construction for McKibben Hospitality. So basically, the way the pre-wire, each letter of the sign has a wire going to it, and so those wires get put through the wall basically and on bolsters, and we waterproof around the wires, and then put the skin or the facade over that, so that you're not basically penetrating the waterproofing with the wire or drilling holes through the waterproofing after the facade and everything's been put on the building.
Sure.
So that's kind of the pre-wire.
Okay.
If that makes sense.
And obviously, the design of the sign dictates the design of the pre-wiring.
Right. Now, usually when there's a sign contractor, they're going to look at the code. I would expect them to look at the code anyway to make sure that what they're designing is in conformity. Were there any discussions with Stratus?
Well, that comes up later.
Okay.
I'm getting to that. So,
Okay.
time and a half goes by. We are told that the permit for this particular sign was not approved and that a variance is needed. And so in late May and throughout June, again, as Mr. Coates showed earlier, we began working on our variance application. And we meet with, Brian and others meet with various city people to understand the process and make sure the application is clear and we're answering the questions and providing all the backup data. And we get that submitted. And then again, here we are back to the variance hearing with the Board of Adjusters, which we were approved at that meeting by a vote of 2-1. That was on 7/17. On 7/18, we reach back out to Stratus, our sign contractor, and tell them to begin fabrication. At this point, we're 6-7 weeks out from the opening of the hotel. We opened the hotel on September 4th. So July 17th was the Board of Adjustment meeting and approval. We're 6-7 weeks out from the opening of the hotel. Of course, 1 week later, on July 25th, we get the notice of appeal from city staff as representatives of the Community and Economic Development Department. City council hearings on the 19th. They overturn the variance approval.
I'm sorry, the city council was that August 19?
August 19th.
Okay, that's okay.
August 19th.
So once you got the notice of appeal, did you call Stratus back and say, time out, we're not done with this yet?
We did not. We did not, because at that point, the opening of the hotel was already set in stone. Hilton had sent their representatives and were mobilizing other representatives to for their final inspections and authorizations to open. We were already getting guest reservations at that point. It was too late to switch and change and attempt to change to get the sign, because we would have never made the hotel opening. So again, understanding that you all might agree, but based on our experience, we felt it was reasonable to, one, after the text exchange with Mr. Green on December 19th and 20th, to authorize Stratus to begin calendaring the pre-wiring, which occurred the week of January 13th. And then after the Board of Authorization, where we got the approval, to go ahead and begin the fabrication. Like I said, we were 6-7 weeks out from opening the hotel. There was not a viable alternative to altering the sign and making the opening. Hilton would not have allowed us to open the hotel without a sign. So, which brings me to my point that it's my opinion, I know you led off with, that it's rare that that violations are irreversible in nature. We disagree in this instance. The doctrine of economic waste by not just us, but by a lot of parties comes into play here. City of Cape Canaveral being one of them. They'll have to spend time with permitting and inspections. We'll have to spend time and money with permitting and inspections and reconstruction and deconstruction and more construction. Stratus will have to do the same. So it's our opinion that this is irreversible in nature. And we understand that there are fines associated with that. And we think that you should find it to be irreversible in nature.
You're asking me to, I'm a little confused here. Are you asking me to issue a fine of $5,000?
I'm asking you to find that the noncompliance is irreversible in nature. And what that means, according to your code, you tell me. You let off with, it could be fines of...
Well, typically, an irreversible and irreparable harm would be property owner destroys a 250-year-old live oak that is providing this magnificent amount of shade and beauty and natural beauty, and they just rip it down. And this really happens from time to time, and in other cities, if not here. And in those circumstances, have represented cities where the argument was made that's irreversible. You're not going to get that kind of magnificent tree again in our lifetime. So that would be deemed irreversible and irreparable. But to say that your company could not hire whoever, if it's Stratus or whoever does the actual installations, to redesign the sign, make it smaller, and take out what was there, and then put back the sign at a smaller scale, I don't think that's irreparable or irreversible. It's additional expense. It is, but I'm not seeing that as irreparable or irreversible.
My point is, based on the totality of the circumstances and what we've described, it would seem to fall squarely in the economic waste for not just McKibben, but for other parties to deconstruct and reconstruct that sign at this juncture. So.
It just seems to me that Stratus should have known what the code was. They should have designed the sign according to the code.
And with all due respect, that's an issue that we'll be discussing.
I mean, you'll need to. I think your beef is with Stratus here, to a great extent, because you would. I would think that you would be relying on them to get it right, to make the city happy, to make Hilton happy. And I don't, when I drive down here every month, I don't close my eyes. So I do know there are a couple Marriott properties across the street. There's there's like a town place, I forgot what they're called, the Spring Hill Suites, whatever they're called.
Right.
And so I just don't, and I did notice your sign this evening. When I'm coming down, I basically looked over my shoulder when I'm heading south, and I saw it. I don't know that the signs across the street are of the same scale. I mean, if it was me writing the code, I would say, yeah, have at it. I think it's to your, and the city's, to everyone's economic benefit, to have a hotel that's easy to find, and the signage helps. But I'm stuck with what the code is here, and I'm not. And there's an admitted violation from what was presented by the city.
Right, we can't say it's in compliance. I mean, that's perjury. Not gonna say that. Brian has,
Sure,
Come up, Brian,
come on up and please.
I just wanted to say that Craig Green was aware that the sign was oversized, but he told me that he would approve it. Without going, he didn't tell me anything about a variance process or anything like that. He just said that he would approve it.
Okay.
text messages.
I know, I don't have anything in writing, but.
But that was an oral conversation you had with
But
them.
yeah, it's a conversation I
Text
had with
messages
him.
indicate.
Right, but
And I think he was new with the city. He was mainly from the private sector. I think he was, he probably wasn't following all the rules. But he had told me that he would approve it. So.
yeah, but on that, and let me just let's in my mind, I'm envisioning this conversation between you and Mr. Green, and he says, "Yeah, I know it's oversized, but I really like it, and I'm going to approve of it." He didn't have the authority to do that, though, and so I mean, if this is not an estoppel case, so it wouldn't be something you could reasonably rely on necessarily, but I just don't. I don't think Mr. Green would have had the authority to just run roughshod over a code that he's actually duty bound to uphold here.
I was also told by someone at the city that I'd called, and she had told me that he did have the authority to approve the sign.
Someone told you he had
At
authority?
the city, yes.
Who told you? I'm sorry.
I don't have her name, honestly. I don't know. But it was the late.
So, based on the text message, really, because the rest is conversation, I understand that. But, he presented in the text message he had authority. We had no reason to believe they didn't have authority.
Oh, yeah, you would. I mean, you're under constructive notice of, certainly your sign company was under constructive notice of the maximum square footage of the sign, which was 160 square foot. So that's really tough from your standpoint. I feel for you guys, because now you got to be dealing with Stratus. You're going to have all this expense of having to replace this with a smaller sign. They got to get up there. They got to make sure the waterproofing is right. The wiring's probably going to have to change locations, and you might need to do some repainting and to make sure it looks perfect. You probably need to get Hilton out again to look at it and give their blessing. I'm imagining. I mean, it's a real.
It's 4 to 5, maybe 6 months of reconstruction on a project that both us and the city deemed complete.
But they didn't.
And it's doing great.
but the city didn't deem it complete.
Well, they deemed a violation.
Yeah, well,
It's complete,
because
but,
the city they gave the certificate of occupancy. They're not trying to hamstring you economically.
Right.
But there was that caveat in there that said, get your sign permits, get that, make sure everything's in I can't remember the exact wording. Make sure everything's in compliance on that compliance certificate. So it was like right towards the bottom where it was check marked on that. Gosh, is there anything else you want? I mean, I'm going to rule in the city's favor as you're probably gleaning from this. But is there anything else you want me to consider?
That's again, we wanted to get our arguments on the record. And,
yeah.
Had a feeling that this was probably the result.
Yeah, I mean, the way I'm looking at this is Stratus had an obligation to get it done correctly. They didn't get it done correctly. The city staff, sitting here, I believe, based on years of experience with local governments, that city staff can make whatever recommendations it wants. They can bring internal appeals. As they did in this case, the city commission reversed the board of adjustment. You had that 1 week between, approximately 7-8 days, I can't remember exactly, between the date of the board of adjustment and then you get this notice of appeal. The notice of appeal is also something that is in the code you have constructive notice of, if not actual notice of it. I obviously was not there, and I always make a notice of the right to appeal. I don't know if they did that during the Board of Adjustment
I wasn't
meeting.
there either. I
Yeah.
wasn't there either.
So, I mean, the record would state whatever that is. So I cannot say that, again, you're not arguing estoppel here. If it was an estoppel case, I don't even think that would necessarily fly.
I don't think that's a winning argument for us. Again, what I see the difference is that the city staff of that department unequivocally has the right to recommend and provide insight onto the variance applications. But are they an aggrieved party according to your ordinance? I don't think they are.
Well,
I think it's a distinction without a difference, because it's one city government department saying to another city government department,
Not a department.
we advised you this, but you went a different way. And I understand you're saying board.
It's a board. It's a board. It's a statutorily created board that can make certain decisions that will allow deviations from the strict enforcement of the code when all the criteria are met. And I don't need to go through all that tonight. I don't think it's germane. Okay. If there's
So with that, I'll rest if you have nothing further for me.
no, and I appreciate your candor, and I'll let the city come back. Unless, Mr. Morgan, if you want to add anything before I go on.
Come on.
I was just curious if y'all had any complaints about the sign. I mean, has the city had any complaints from the public about the sign? You said you
I don't
didn't
know.
feel it was egregious.
No. If I was writing the code, I'd let you have that sign. But I'm not a city council member, so I don't have the authority to even vote on something like that.
Okay.
No, I mean,
I was just curious if y'all had gotten any complaints about it.
well, I don't know that. I mean, the city, if they want to volunteer an answer to that.
It's our understanding from hotel staff that they have not, but that could be incorrect.
Okay. And I don't know that if there is a complaint or not, whether it matters really. Anyway, you want to?
I just have, given their presentation, I have a very couple of questions.
Of course.
Your Honor, I'm looking at the Stratus proposal.
Do you want to just introduce yourself for the record?
I'm sorry, Anthony Garganese, City Attorney for the City of Cape Canaveral. I'm looking at the Stratus proposal. Can you identify where on this proposal the subject sign is itemized?
I'm sorry, it's so small. I'm not sure it is itemized. You'll have to look at it, because
Do you
he
wanna-
knows the contract better than I do.
Yeah, if you'd come up and speak into the microphone, so that way your answer is on the record as well, Mr. Morgan.
That's the way it's given to me, Brian, I'm sorry.
No, all good.
I don't think you'll see itemization of any signs. I think it was for all signs applicable to the hotel.
I think it's one of these first two. There's the 42. I think it's the first. I think it's the first one. The first one. The 42. It says 42 inches. I think it's supposed to be 42 feet. Yeah, I think it does. I mean, not the record reflect.
Could you speak into the microphone, because otherwise it's not going to pick up on the recording.
I mean, I'm looking at this and it's in inches. It's talking about a 42-inch linear illuminated letter set logo.
I think it's saying 42 feet.
And then I'm looking at this, the city's exhibit that was submitted, the color rendering of the sign that was
Right, I think, yes, that was part of the variance application.
prepared by Stratus. It's this exhibit right here.
Let me get to there. Okay, I'm looking at it.
And I just don't see on this exhibit, maybe they could point it out, where there's a 42-inch linear illuminated sign. The dimensions seem to be much longer than that in feet. So I just question whether this contract was actually for the subject sign that we're dealing with tonight. I just wanted to point that out.
Yeah, so I'm looking at, let me show you what I'm looking at. Which is this page here, Mr. Garganese, where there are some dimensions. You have this. And so
Correct.
that indicates the height of the letters appear to be 3 feet 6 inches. So that'd be 42 inches. And so the very first one would be 42 inch. I believe this is referring to the very first item on the description. And please correct me if you think I'm wrong on that.
My question is whether or not this sign is on that form. That was just my question.
Okay. I mean, it seems to line up. The numbers seem to line up in my initial look at it.
I mean, that's responsive to my question.
The way the sign was calculated, the square footage, because I had them run it a different way, because the way y'all calculate square footage and the way most jurisdictions calculate square footage are totally different. So the way the 250 square feet is calculated, it takes the logo, the size of the logo, which is bigger than the letters, and it goes all the way straight across at that same 5 foot 7/8, all the way across. If you calculate that separate from the letters, you're at 183 square feet. I was going to show this tonight, but 183 square feet. If you calculate it by individual letters, it's 140 square feet, the sign. Way less than 250 square feet. So, does that make sense?
Well, my question is whether or not it's just on this contract. You're saying that it is, and it appears to be the first line item. That was my question. I just wanted to bring out on the record whether that contract was related to this sign. And, and with respect to his comment regarding the square footage, if you look at that diagram, Your Honor, that you had held up, right at the top, it actually states the sign is 250.5 square feet.
That's right. I saw that.
Okay.
Yeah. There's no question in my mind the sign is oversized, and I think these folks have a real beef with Stratus. And then would Mr. Officer Coates, would you like to give any other remarks, including remarks, recommendations?
City would like to recommend, staff recommendation, based on the testimony and the evidence presented at this hearing, staff respectfully requests that the special magistrate find the respondent in violation as set forth in the notice of violation. Staff further recommends
In violation of the code provision set forth in the notice of violation.
Okay.
Okay. All right.
Staff further recommends that the respondent be granted until November 26, 2025 to apply for and obtain the required permit from the City of Cape Canaveral and remove the unpermitted and illegal wall sign installed on the upper level south facade of the building, oriented perpendicular to Imperial Boulevard. Removal of the unpermitted and illegal sign is required to bring the property into full compliance. If the respondent fails to obtain the permit and remove the sign by the deadline established above, staff recommends that a fine of $250 per day for each of the 2 violations be imposed until compliance, defined as complete removal of the unpermitted sign, is verified by the code enforcement officer. Staff further requests that all costs associated with the enforcement of this violation be assessed against the respondent.
Okay. let me make sure I'm understanding the request, that the application for removal must be submitted to the city by November 26, 2025. And I don't have,
It's the day before.
okay. So this is November 26th, that's the Friday after Thanksgiving?
No,
It's the Wednesday before
The Wednesday before, okay, all right, okay. And then, so they get the application in by November 26, and then do they need a separate application for a new sign that meets 160 square foot?
Yes, sir.
So they need two different applications?
Right.
All right, and then, does that application also have to be submitted on, or by November 26?
Apply for it. Yes, sir.
So we want them to apply.
Let me answer the
Okay.
question. Whether they want to put up a sign, another sign that's compliant with the code, is totally a separate application. That's not at issue. What's at issue tonight is that the city is requesting that, Your Honor, require that they not only apply for the permit to remove the non-conforming, non-compliant sign, but also remove that sign by November 26, 2025. That's
Okay.
what the city is requesting. Now, once they remove it, it's their choice. If they want to put up a compliant sign, they already have a compliant wall sign on the western face of the building. They certainly can, I think they know the process to get a compliant sign. That's a different issue.
Okay, so the request from the city is to put into my order that they not only apply to remove the existing southern facade sign, but actually remove it by that day.
Yes, sir.
Okay. Now, assuming they need to I'm just trying to think of what's fair here. They need to fabricate a new sign that's going to be, it's going to meet the city's ordinance, and I don't know how long that takes to get the fabrication done. You know, is that a and I'll let them respond to this after you. Is November 26th, is that enough time realistically for them to be ready to go? Because when they take that down, regardless of whether I say they would have to put up a new sign, I'm not going to force them to put up a new sign, but the reality is they will, because they need it economically. So they're going to want to do it pretty quickly, at least if I were in their shoes. Is that enough time, November 26th? I'm going to let them speak first, and I'll let
I guess
you.
that's a response for them. Again,
Okay.
whether they put up the timing of putting up a compliant sign, I think is on them, not on the city. And this proceeding is about determining whether or not there is a violation of the code and taking a remedial step. This is, Your Honor, this is a case where not only was the building permit denied for the subject sign, the variance application was denied for the subject sign,
Yeah.
and it went to the city council, right? And it was denied by the council. What's at stake here, Your Honor, is the rule of law. Notwithstanding the denials, they still went ahead and installed the sign.
Right.
Right, they were concerned, based on Mr. Coyle's letter, about the opening of the hotel. Well, that was never an issue for the city. The city allowed the hotel to open. Once they got their CO, it wasn't long thereafter that this sign went up in violation of the code, in violation of a decision made by the city council of City of Cape Canaveral. The rule of law is at stake here from the city's perspective.
Okay.
So we don't have a problem with them putting up a compliant sign. If they can work really hard and get, put in a permit with their removal permit, so be it.
Well, I think
The city will
Stratus owes them.
expeditiously process it.
I think
But
Stratus.
it's on them, Your Honor.
I think Stratus owes them, but anyway, go ahead. Mr.
Could I make one?
Of course.
This sign was on September 5th. This is a Friday.
Or
sign
the
was
the
not
5th or
there.
the 7th? I think I wrote down this.
September 5th,
Okay.
there was no sign there. September 7th, there was a sign.
Okay.
So that's how quick this sign was put up. So
Okay.
taking it down should be pretty quick too. I would think.
Okay,
So
all right. I'm going to let Mr. Morgan or Mr. Coyle, again, address my question, is November 26th, is that enough time to really take care of this?
The answer is no, in that we don't object to showing progress towards, but Hilton has brand standards. Hilton will not let us operate that hotel without a sign. So if we remove that sign and not have a sign there, we'll have to close the hotel. That seems like an egregious penalty for what we're discussing here today. What will need to happen is we'll need to get the sign redesigned. Let's assume we engage Stratus again. We'll need to get the sign redesigned. We'll need to get that through Hilton's approval process. Hilton traditionally goes through a dead period over the holidays where they don't do any of this type work. Hilton and Marriott are very hospitable, and they give their employees lots of time off during this time. I don't know exactly when that falls. I wasn't anticipating speaking to that. There's no way that we'll be able to take that sign down and be ready to reinstall one. Mr. Coates is correct. It doesn't, once you get everything else done, the actual installation of the sign is a couple days at most. But what goes into that is we have to remove the sign, we have to remove the stone veneer and the foam that's beneath it, we have to rewire, we have to waterproof, we have to reapply stone veneer and foam, and then you install the sign. All that doesn't even start until you get a new sign designed, a new sign approved, permits for all of this. And so November 26th, which is 3 weeks away, and we got to fabricate, which is, excuse me, that's right. You got to build the thing once we get it approved, and that's 30 to 45, maybe 60 days.
All right.
6 weeks minimum.
All right.
So, 21 days is there. That's no way.
Well, that's why I asked the question. Here's what I'm going to do. And I realize this is all over the holiday season. You guys are going to be under the gun to get this done. Okay? There's just no ands, ifs, or buts about it. And you're going to need to really ride the horse wild here, both Stratus and Hilton, to get this done. But this needs to get taken care of. And Mr. Garganese raises a really good point. There was from the city's standpoint, it looks like defiance of both. You're putting a sign up without a permit. I mean, that in and of itself is a huge red flag. There are a lot of individuals come before me with a lot less sophistication than what you guys have.
May I ask you that real quick?
Yes.
I heard what he said, the rule of law is at stake. We didn't come to be a part of Cape Canaveral and develop a hotel and be a neighbor to flaunt the rule of law and be at constant odds with the city. That's okay. It's not what we've done for the last 6 decades, and that's not what we want to do here.
I understand.
So,
all right. So it's November 5th. I want this taken care of. Again, I realize it's over the holidays. This is going to be tough. But you do, looking at this calendar here, I think the 26 is just it's too aggressive for what you need to do.
Without question.
I'm gonna push this to December 24, day before Christmas. Okay, and I realize it's very aggressive still, but this has got to get done. The violation is pretty blatant when it's put up there without a permit. It's contrary to the wishes of the city council here. So that gives you 1, 2, 3, 4, 5, 6, 7, almost 7 weeks. We could could extend it, over into beginning of the New Year's, but everything is very difficult to get done anyway between Christmas and New Year's, and I'm not sure that makes any difference, frankly.
If I may,
Yes.
because a lot of this is somewhat unknown to us because we have to hire folks to do this. So we're now depending on third parties and their availability. What I would like to propose is that, because I don't think we'll have the sign in a position to be taken down even by the 24th. What I would like to
Well,
propose
then fines would start accruing.
is, if I may,
Yes.
We have the permitting process. We have a new sign designed. We have Hilton approval, and we have the permitting process going by the December 24th with a plan, a detailed calendared plan of removal and reinstallation. Even if,
By when?
well, I don't know that off the top of
Well,
my
I'm going to have to come up with a date here. So I'm giving everyone an opportunity to try to plan something in my mind. What is reasonable? What is fair under all the circumstances?
It's hard to, I feel confident that we can be ready, that we can have the permits processing in place by the 24th, when we can have contractors out to do the deconstruction and reconstruction. I mean, Brian, I don't think we can speak to that because we haven't spoken to those folks. We don't know their schedule. I don't know how, again, this is to the formality and the procedure here. If we could be given a week to come up with that calendar.
No, I'm gonna come up with something tonight. All right. I want the permit application submitted by December 3rd. That gives you a month. All right, to get this done. And you guys already have a pre-existing relationship with Stratus. In my view, they owe you one here because I think they got you into this mess, and they need to make it right. And if not them, you got to jump on someone else really quickly. But you got a month to get these permit applications submitted. And then for the installation, I'll allow another month by January 7 to get this reinstalled. That gets you, I mean, technically it could get you beyond the whole Christmas, New Year's season. So if the sign is down for a day while letters come down and new letters go up, you would have a little bit of leeway right after January 1st to do that.
Hearing what Mr. Morgan just said is that it's 6 weeks to fabricate, and we
Okay.
won't be doing that until after permits are approved. So if permits are approved on December 3rd, or permits are submitted on December 3rd, let's assume they're turned around and approved on December 4th, 6 weeks to have the thing ready is already middle of January. We're already in violation through no fault of our own.
Well, I think it is the fault of yours, frankly.
In this instance, in this
right.
specific conversation
All
we're
right.
having.
All right, I'll extend it to January 14 to get it, the old sign removed, the new one put up by January 14. That allows some time for fabrication, and again, you're going to have to really ride herd on the third parties who you're having to rely on here. But then on January 14, if it's not done, then fines will start at $500 a day. That's for $250 for each of the two violations, which was.
And to be clear,
Yeah.
all that needs to happen really at that point is to make sure that the non-compliant sign is removed.
Well, that's true.
That's the violation.
That's true. That's true. So you could remove the sign.
Again, it's
By
my
January
position that
14.
Hilton won't allow us to operate the hotel for
Well,
much
that- well,
longer
that-
without a
that's
sign.
between-
But that's us. But
between you and
January
Hilton.
14th is to remove the violation.
That's what I would, I think given the holiday season and,
Again, we're not going to
The-
operate
the
the hotel
realism
without
here.
a sign there. That's.
yeah, so this has given you, 2.5 months to get this mess fixed up. Mr. Garganese, you want to,
Yeah,
add, and feel free to disagree with what I'm coming up with here, but
Yeah, I'm just trying to sort out, I think Your Honor said that you were gonna give them until December 3rd for a permit application?
to get that, right, because they're going to need to get this thing redesigned and whatever drawings they need to submit with their permit application. So there has to be a little bit of allowance to have Stratus or whoever's going to be doing that, get those engineer drawings done. So I want to give a little bit of leeway for that.
Okay, so Your Honor is, I guess the installation of a new sign is part of the compliance? order
Yes.
to
Well,
remedy?
no, it's not. No, the installation is not. The removal is, but knowing I'm just being sensitive to the economics here of them having no sign during the holiday season coming up. You have a bunch of tourists here wandering around Cape Canaveral looking for the Hilton Garden Inn, driving northbound and not seeing this thing. We're going to have some irritated holiday goers around town if they can't find this building, and they're going to be driving by it. And I'm just trying to be realistic here. What I think is what they're going to end up doing. They're going to want to switch these out in pretty short order. What I'm right now leaning on doing, it's really giving them, 2.5 months to get this all taken care of. You want to disagree with me or add anything else you'd like me to consider?
I don't, yeah. I mean, I don't know if you have a question, Connor? Because Connor's the
Sure.
person that will be processing applications.
Just one clarifying question I
Yes,
have,
sir.
Connor Ford, Senior Planner, is for that December 3rd permit submittal date, would that just be a removal permit required, or would they also have to submit for what the new sign would look like on that day?
Well, from what I'm hearing from Mr. Garganese, we don't care about the new sign
Yeah.
or the size of it, but I would think that they're going to want to do both simultaneously. I would if I were in their shoes.
Yeah, I'm fine with it either way. I just want to make sure that I have clarity on if they only submit for a removal permit, if that is sufficient, or if they also need to submit for what the new sign will be on that day.
Yeah, I'm thinking they're going to end up doing it both together.
I
But go ahead.
would suggest if Your Honor is going to include the new sign as part of the compliance order, we would expect that the respondent would submit a complete application to remove the existing sign and a complete application for a sign, I'm presuming a wall sign, that is in compliance with the city's code, which is a maximum of 160 square feet for the wall sign. And that
Right.
those permit applications be submitted by December 3rd, so the city will have an opportunity to review.
Right.
And if we issue that permit for the compliant sign, they have enough time to get it manufactured, and then getting the non-compliant sign removed and the non-compliant sign removed by January 14th.
Okay. I think it's not perfect, but I think that's reasonable. Given the holidays, and these guys are gonna have a time dealing with Stratus and Hilton, whoever else they're dealing with. All right. Is there anything further that I need to do tonight? Mr. Coates, I don't think we have anything else on the agenda this evening.
I don't think so, Mr. Giller. I think you got it pretty squared away now.
All right. Well, good luck to all you getting this sorted out, and I'll issue a written order indicating these deadlines and my finding of the violation exceeding the 160 square feet. And it will also reflect the timeline that was presented here this evening. So with that,
One more question, Mr.
Yes, sir.
Giller.
Yes, sir.
This sign This sign should be installed by the 14th?
No,
No.
no, they have to remove it by the 14th. So,
Okay. Okay.
So if they need a little more time, at least they're beyond the holiday season. We're not going to have a bunch of lost tourists.
According to Mr. Coyle, they will not remove it without having one in place, so it'll go hand in hand.
That's what I would expect to happen
Okay.
here.
All right.
Okay. Mr. Coyle, do you have anything else before we adjourn?
I'm sorry, I'm signing. I did it backwards, I'm sorry, I signed in the print.
That's fine.
That's all good.
Fine. Thank you.
No, nothing further.
All right.
Just wanted to make sure that we're all on the same page as it relates to what January 14th means, and that means
Removal.
the sign's off.
That's right. That's right. And then-
Hilton and McKibben is not going to operate that hotel unduly longer than is needed without a sign.
That's right.
And I'm not sure Hilton will let us operate for too long without that sign. But once that sign is removed, you don't just put a new sign up.
I understand.
So
I understand.
it won't happen the next day. It may not happen the next week. It may not happen the next few weeks, because we then have to rebuild and rewire and rebuild the structure to support the new sign. So it's not a take it down, put it off in the matter of 3 days.
That's right. And
So there will be-
that reiterates my understanding of
Right.
what we covered,
So
and I'm
if
sure.
the
Ms.
removal of
Morgan-
the sign by January 14th is what the marching orders are, in
That's
addition
right.
to the permitting process on the 3rd.
That's right.
Understood.
Very good. If there's nothing else, I'll go ahead and adjourn for the evening. So, thank you all.
Thank you.